Folks, we're going to get started with our presentation here today in our panel. First of all, my name is Craig Mastantuono. I am the managing partner of Mastantuono & Coffey Law Firm here in Milwaukee and an adjunct faculty member here at Marquette University Law School. On behalf of the law school and Dean Joe Kearney, first of all, thank you to Marquette University Law School for hosting our great event, and welcome here today. I'm here to talk to you just for a few moments and introduce our panel moderator and our mayor. But I want to talk for a moment about the American Constitution Society. The ACS is the premier progressive legal network in the country, building networks of lawyers, law students, judges, and policymakers dedicated to the idea that our Constitution and the law should be a force to improve the lives of all people. So as the current chair of the Milwaukee chapter of the American Constitution Society, to borrow a phrase of a great political leader, I am here to recruit you first and foremost as we start our event. If you believe what I just said about ACS, then you should be with us and you should be a member of the American Constitution Society. If you believe that our Constitution has been hijacked by people ginning up the idea that our Constitution is at its best when it does the least, if you don't believe that, you should be with us and you should be a member of the American Constitution Society. If you, like those of us on the other side, believe that the framers intended the Constitution to be an evolving and positive force reacting to the changes in society and providing guidance and a framework for the challenges that we face as a society, then you should be with us. You should be a member of the American Constitution Society. If you want a place in a group to connect with others who are committed to these ideals, to be in the mix intellectually and socially here in Milwaukee and in Wisconsin on national ACS efforts, then you should be with us. Did I mention that for private practitioners of law, it's only $50 a year? For public practitioners of law, it's only $25 a year. And for student members, it is free. If I haven't, and you didn't know that, and you know it now, then please join us. You should be with us. All of you who RSVP'd to this event will be sent an email with a link on membership renewal and membership engagement. And that link will, for payment of your dues, however applicable they may be, entitle you to membership through the 2017 calendar year. You can sign up right now for membership and you get, a couple of months for free in 2016 by using the link that we're going to send you. If you did not RSVP and provide your email, there is an email sheet for writing that information on the end of each table in the rows. Please add your email to those sheets. We'll collect them at the end, and you will get the link that way. I want to introduce just a few more people before we introduce our mayor. Amy Gardner is the American Constitutional Society National Director of Lawyer Chapters and is here with us today. She's based out of Chicago, so we thank Amy for joining us. And National American Constitution Society provided our lunch here today, provided a budget for our lunch here today. And I have to say a few words about the Voting Rights Institute that National ACS is engaging right now. So, the Supreme Court's 2013 decision in Shelby County versus Holder invalidated the coverage formula of the 1965 Voting Rights Act, the most effective civil rights law ever enacted, and has led to an assault on voting rights across the country. In its wake, state legislatures have passed discriminatory voter ID laws, rolled back early voting periods, and increased voter purges in what constitutes one of the greatest threats to American voting rights in more than a generation. In response to this crisis, the American Constitution Society, the Campaign Legal Center, and Georgetown University Law Center have launched the Voting Rights Institute to help attorneys, expert witnesses, law students, and others publicly combat discriminatory voting practices across the country. The VRI seeks to train and empower the next generation of voting rights attorneys and to ensure that attorneys handling voting rights cases have a wealth of resources and scholars available to assist in litigation development and presentation. I mentioned earlier that Marquette is our host here today, and I do have a required word from station management. The views expressed here today are those solely of the speakers and not of Marquette University. The use of Marquette's facilities does not constitute an endorsement of any political candidate or office holder or of the views expressed. No fundraising is permitted at this event. Thank you for that moment. Our event here is co-hosted, if you haven't guessed by now, by the American Constitution Society, the Milwaukee chapter of the American Constitution Society, and the student chapter at Marquette University Law School of the American Constitution Society. I do want to introduce Courtney Rowlands, please, and Natalie Wisco, President and Membership Engagement Director of the student chapter of the Marquette ACS. Thank you. The student chapter has over 70 emails on its list, regularly has 30 or more attendees at its events here at the law school, and a regular and strong presence within the Marquette community. Courtney and Natalie, thank you very much for all of your work putting this event together. It was instrumental. Can I have the other student chapter board members please raise their hands? We have several student chapter board members present, and I know that we have many members of the current Milwaukee ACS board. And so thank all of our board members for being here and new and prospective members. I think I would be remiss if I didn't say that it's an exciting timing moment for this event as we are engaged in a national presidential campaign and debate where one of the small group of two people, one of whom will be the next President of the United States of America, is currently engaged in wild allegations of claiming that our elections are rigged and that there's massive voter fraud. On the heels of that remark and the timing, it's really great to meet today's litigators engaged in voting rights and to talk about current cases. But we're joined by our special host here today, Milwaukee Mayor Tom Barrett. Mayor Barrett was elected in 2004 and re-elected 3 times since, most recently earlier this year. In August of this year, after Judge Peterson in the Federal District Court in Western District of Wisconsin struck down a series of voting rights restrictions in Wisconsin, Mayor Barrett publicly praised the ruling, saying that without question, the city would take advantage of it to help more of its citizens vote. The mayor stated, and I quote, "Governor Scott Walker and the legislature wanted to create a bottleneck in the city of Milwaukee and to make it more difficult for people to vote." Ladies and gentlemen, I give you Milwaukee Mayor Tom Barrett, a strong public leader and advocate for voting rights in Wisconsin. Mayor, thank you for being here today.
Well, good afternoon. Thank you very much for having me. I'm excited to listen to the panel as well. And it's always great to be at Marquette Law School, so I want to thank you very, very much. To the students, I have some career advice to give you in a couple of minutes, but I want to start out, and I'm going to show my age here, and I recognize a lot of people in the audience. But I have to acknowledge that when I first got involved in law, and then ultimately politics, I was a little like Gomer Pyle. And I use that name. The younger people probably don't know who Gomer Pyle is. The older people know who Gomer Pyle is. But I was a little naive because I never understood that there was, as you referred to it, the other side. I just never even thought about it. That's how naive I was. I never thought there was the other side. And in fact, I think to some extent there wasn't an other side at that time. In fact, when I left law school, I clerked for a Republican judge. And that, for many people in the community, particularly in the liberal part of the community, that made me suspect maybe for the rest of my life, but for many, many years. But now, as I have a little gray hair, I can finally tell you the true story on how I got that job. And this is important for the law students, because I think we all, as law students, have these perceptions of how things happen. So I grew up here in Milwaukee. I went to Marquette High School, but then I went to school in Madison and got my undergrad and went to law school there. And in my second year in law school, I signed up for a judicial clerkship. It was an internship where one day a week I would travel to Milwaukee and clerk for Judge Robert W. Warren, a gem of a man, a wonderful man who had been appointed by President Nixon on the last day he was President of the United States. But I got a job working for him. So how did I get this job? So I came to Milwaukee, and to show you how naive I was, I showed up for the first day for this internship, and I didn't even have a tie on. And I was in the courtroom, and as I was leaving the day, the clerk was kind enough to say to me, "Next time, wear a tie. You're supposed to wear a tie whenever you go into the courtroom." And so I learned very, very quickly. But what also happened was I would come in one day a week for the whole day and help draft opinions and orders and things. And there were a couple of women who worked in the office. One was the secretary, the other was the court clerk. And they asked me whether I wanted to play Scrabble with them for lunch. And I had played Scrabble with friends at that time. I said, sure, I'll play Scrabble with you. So I played Scrabble with them. Well, every week when I came back, I played Scrabble with them, the two people in the office who were not attorneys. And as we got near the end of the semester, they said, well, of course you're going to apply for the clerkship, aren't you? And I said, no. Those are for the really superstars. I was a solid student, but I wasn't one of these guys that we all hated, who was just so smart. It was unbelievable. I said, no, that's for the skyscrapers. And they said, no, you should apply. So I applied, and to this day, I am 100% convinced I got a clerkship with a federal judge because I played Scrabble. And I tell that story to my kids who are now in school. I said, it's important to be nice to everyone in a workplace. You don't know who the true decision makers are, and it's important to be nice to everyone. So I got that job, again, working for a federal judge. And as I was leaving the clerkship, I told them I was going to be running for the state legislature as a Democrat. And I still remember him rolling his eyes like, oh my God, we failed. But we had a good friendship, and it was a friendship that I treasured the rest of my life. And it was because the walls were not as high as they are now. And I never dreamt that there was a need to have one school of thought, if you will, ideological thought, about the law, because I just didn't. Maybe that'll show you why I wasn't at the top of my class, that I didn't discern that as much as I probably should have. Well, fast forward 30 years, and I think we all recognize now that there are certainly forces out there who have made concerted efforts and deliberate efforts to make sure that only one type of thinking permeates our court system. And I don't believe it started from our side, as you describe it, the litmus tests and everything that goes along with this. So I don't view what's going on here as their side and our side. I really do view this as their side and the Constitution's side. That the Constitution, as you said in your introduction, is a document that the framers understood had to be viewed in the context of what was happening over time, that it was not a static document. And quite honestly, I feel that sometimes those interpretations, and I can say this now as a former member of Congress, that we would hear local control at Congress and at the state, unless the other side had the control. Then it was all of a sudden that concept was out the window. Having said all that, this, I think, for purposes of right now, is most timely when it comes to election law. Because as a member of the legislature, I remember with pride seeing how Wisconsin was a national leader in providing access to people to vote. And I thought, again, naively, this is great. The understanding that our democracy works best when more people are involved is something that every American should believe in. And this is just a wonderful, wonderful sign of how good our state is. Then, of course, we have had the last 6 years. And what has happened over the last 6 years, and it didn't start in Wisconsin, but Wisconsin and the leadership in Wisconsin, I believe, signed on in blood, if you will, to say we are going to make a concerted effort to make it more difficult for some people to vote. And if you look at Judge Peterson's decision that really led to where we are right now in terms of the city of Milwaukee and the changes we have made in the last month, he specifically made a reference to attempts to make it more difficult to vote here in the city of Milwaukee. That this has not been an accident, that this has been a concerted effort to make it more difficult, because the people who created this legislation know that in the recent history that in this city it's going to be a 70-30 split, or perhaps even greater than that. And so there has been an intent to make it more difficult for people here to vote. That's why when the decision came down, we made it clear that we were going to try to not make it more difficult for people to vote. And we, again, expanded the hours for early voting. And we have additional sites now, which have been very successful. In fact, I will tell you this, we have had now about 13,000 people who have already voted in the city of Milwaukee in our 3 different locations. The one having the greatest turnout is on the north side at Midtown. The shopping center at Midtown has about 47% of the people who are voting there. And that has access, it has good parking, it has good walkability, it has good access to the bus line. So a lot of people who it would be more difficult for them to vote are able to take advantage of their constitutional right to vote. And I'm proud of that. I'm proud of that as well. On the south side, we have a site at Forest Home, and we have the site at Zeidler. Now, having said that, I will also share with you that from, quote, our side, I had people who were pushing me to do even more and more and more. And my response was, look, you guys are in here working on a campaign. You're going to be gone after this campaign is done. I still have to run an election. And if this gets screwed up, you're long gone, and we have to explain it. So you can have all these great designs for having a gazillion different locations or this, that, or the other thing. But I view my role as, first and foremost, as the mayor of the city, making sure that we have fair, competently run elections. That's number one by far. Number two, and a corollary to that, is, again, making sure that people have access to the polls in ways that don't discriminate against people. And I think that we've achieved that balance. So even in this last month period, I've had people who felt we didn't go far enough. And I stand before you saying I think what we have done is we've achieved the balance that is necessary to make sure that people have the access to the polls, but have done so in a responsible fashion for the taxpayer and for the electorate. And of that, I'm very, very proud. So I want to thank you for being here. We're going to hear more today, obviously, about the challenges we face. But I am definitely happy to see that you are even here, all of you, because this is important, that we have people who care about the Constitution and a fair reading of the Constitution. So, Craig, thank you very much. And again, thank you to Marquette University.
Thank you, Mayor.
Thank you.
We're going to end today's event, start wrapping it up at 1:15. We are fortunate to have Marquette University Law School Professor Ed Falone moderate our event here today. Professor Falone has been with Marquette since 1992. After exiting private corporate practice, and teaches courses in business organizations, comparative constitutional law, corporate law, immigration law, securities regulation, and white-collar crime, and is a strong intellectual and progressive voice in our legal community here in Milwaukee.
And furniture, too.
and rearranges furniture. One last thing. ACS is a fully engaged 501c3 and not engaged in direct political advocacy or fundraising. For my prosecutor and judicial office holder friends here today, you did not forfeit your First Amendment rights when you became office holders or prosecutors. To quote Judge Joan Kessler from the Wisconsin Court of Appeals, who's here today, who could be against the Constitution? Board member Joan Kessler. So please join up. Thank you very much, and Professor Falone will wrap up the event and introduce our speakers. Thank you.
Okay, I'd like to ask our speakers to come forward and join me on these lovely chairs.
How do you?
Yeah. Why don't I put on the end?
Only because the mics, I have to pick these up.
Okay, so hopefully the mics will be able to pick up everything as we talk. I'd like to introduce our panel. We're very fortunate to have an outstanding panel with us today to discuss Wisconsin voting rights litigation. Starting on my left is Joshua Call, an attorney at Perkins Coie. Everyone was afraid I was going to mess that up, but I know how to pronounce Perkins Coie. Josh's work focuses on voting rights litigation, and Josh is currently involved in cases challenging voting restrictions in several states, including here in Wisconsin. And the case, One Wisconsin Institute versus Thompson, was tried before Judge James Peterson in May. We're very fortunate to have the named defendant with us today. And that case resulted in the invalidation of several recent changes to Wisconsin election law. That case is currently on appeal. Before joining Perkins Coie, Josh worked as a federal prosecutor in Baltimore for the law firm Jenner & Block and as a law clerk to then Chief Judge Michael Boudin of the First Circuit. Josh is a graduate of Stanford Law School, where he served as president of the Law Review. In the center, we have Karen Rochter with us. Karen serves as the senior staff attorney for the American Civil Liberties Union in Wisconsin, heading its Poverty, Race, and Civil Liberties Project. She works on such issues as transportation and environmental justice, voting rights, fair housing, police misconduct, and immigrants' rights. Prior to joining the ACLU in October of 2001, she spent 15 years working with migrant farm workers, low-income families, and senior citizens as a staff and supervising attorney for legal services programs in Ohio, Texas, and Wisconsin. She is a 1986 graduate of the University of Wisconsin Law School. And last but not least, on the far left is Matthew O'Neill. Matt is a shareholder at Fox O'Neill and Shannon. His practice focuses on commercial litigation, appeals, arbitration, shareholder disputes, and election and campaign finance law. Matt graduated from Marquette Law School in 1991, in the old building, as they say. Since 2004, Matt has trained lawyers to observe at the polls on behalf of the Democratic Party, vigorously trying to ensure that every eligible voter gets to cast a vote that is counted. In 2005, Matt testified before Congress about voting rights issues, including voter suppression efforts, the real problems with heavy turnout elections, and the absence of voter fraud. He has litigated numerous election issues in the past, including HAVA cross-check challenges, attempted City of Milwaukee registration roll purges, and ballot access cases. Please join me in welcoming our panel. So I contacted our panel and I said I was going to start by asking a very simple question, and they immediately all expressed disgust and unease with my question. But I think it works for purposes of our discussion to start at the basics. And so my first question for the panel is, where exactly does the right to vote come from, and where is it located in our constitutional system? And I'll just see.
And here I have an idea. The only thing I brought with me, everybody's got their paper, I have the Constitution here. This is a constitutional discussion. And there actually is not in the Constitution proper a right to vote. The only mention or the only implication is in Article 1, Section 2, that allows the people, capital P, people, to choose, C-H-U-S-E, their representatives in the House of Representatives. And that's it. That's all you get in the Constitution. It was not until they started amending the document, in fact, got all the way to number 14, that the words right to vote show up. And the first reference is in the 14th Amendment, and it talks about you lose a little bit of your proportionality if you deny the right to vote to white males over the age of 21 for reasons other than treason or felonies. So that's the glorious first occurrence. Then in the 15th Amendment, we get around to make some sense, and the right to vote can't be abridged on the basis of race. And then in the 19th Amendment, we get even more modern, and we say the right to vote can't be abridged on the basis of sex. Thank goodness it took that long, 19 amendments, to get women the right to vote. And then we come flying along all the way to, I think, the 24th Amendment, where it allows the right to vote for can't be abridged by a poll tax. And in the 26th Amendment, we lower it down for 18-year-olds. So it's not expressly in the text of the Constitution, but it is in there 5 times stating the right to vote in the amendments. So in my view, yes, it is a basic fundamental constitutional right.
Anything to add?
I would just add, and the Supreme Court has interpreted the 14th Amendment, the equal protection guarantee, as also protecting the right to vote. They've established various tests and standards for it, but that is, for many decades now, how it has been interpreted.
Yeah. Do you think there's a tension here between arguments that we need to protect the substantive right to vote and arguments that, you know, any voting law or voting restriction is fine as long as everyone is treated equally? I mean, is that a tension that you see in the precedent? And I'm thinking in particular the 2008 Crawford versus Marion County Board or Election Board case, where the Supreme Court upheld Indiana's voter ID law. It seems on to me, a very deferential standard of review.
So I think there are sort of 3 core interests that the right to vote protect, and I think they're complementary, actually. One is what we think of as sort of a fundamental right. I think if they were just to cancel voting for governor for Wisconsin, people would rightly be up in arms in the streets. Nobody thinks that that's an appropriate way to run a government, in part because we think that we as individuals have a right to weigh in on who our leaders are. It's also associated with the First Amendment. You know, we have a right to assemble, a right to speak. That right doesn't mean a lot if you can't go out and exercise your right to vote in connection with that. So that's one of the interests. A second interest that has sort of been revealed as important, I think, through the history of our country is an interest in equality. Equal access, particularly by race, but also by lots of other categories, age, gender. So a second right that often is at issue in these cases is equal access to the ballot. And then a third right, and this is the one that I was thinking about in light of the discussion at the beginning today, is a sort of democratic norm. And this is the point that you were making about the people being in charge of the government. When you have a system that prevents a large number of people from voting because it's so difficult, it calls into question the vibrancy of our democracy and how well we're actually living up to the promise we all learn about in school, which is that, you know, this is a majority rule country. To the extent that you are limiting access and making it hard for people to vote, you're undermining that principle. And I think some of what we're seeing in current political discourse, since this is a 501c3, is a product of efforts to undermine that norm and the norm that everybody should have access to the right to vote. You know, for about 40 years in this country, from 1965 until about the mid-2000s, there was a basic agreement, at the federal level at least, that voting was a good thing and that we should make it easy for people to vote if we can. But over the last 10 years, particularly since Crawford, and it's been accelerated, of course, by Shelby County, the Section 5 case, that's no longer a principle that we can sort of take as a given that we all agree on. So those are the interests I see as fundamental.
So let me just speak to Crawford, because I think it is often used as an incantation. Well, in Crawford, they said Indiana can have voter ID, so everything's cool. First of all, it's important to recognize Crawford was a 3-3-3 split decision. Crawford was also a facial challenge. They did not actually provide, or at least as interpreted in the record, evidence of people who didn't have ID to vote. It was just saying, under all circumstances, this law is unconstitutional. And in the 3-3-3 split, you know, the opinion that ended up upholding it basically said, well, there's no evidence here that, you know, any substantial number of people are going to be burdened. It would be different, A, if there was evidence, and B, if for subgroups of populations who have difficulty obtaining ID. And what they did in Crawford was use what's called the Anderson-Burdick balancing test, which comes from the Anderson case and the Burdick case. I'm not going to cite full cites out here, which sort of weighs the nature of the burden the election law imposes against the interests of the voters and how those voters are burdened. And they said, here in Indiana, on the record we don't see, essentially, we don't see the burden. We don't find it significant. This law, as it stands, can go forward. I don't think Crawford, on its face, and certainly as interpreted by other courts subsequently, Seventh Circuit notwithstanding, means that any voter ID law is perfectly fine in any interest the state wants to, I swear I almost said Trump up without even trying. So I'm sorry about that. Make up in order to justify a voter suppression law is valid. At least from our perspective, we interpret it as when you put evidence on the record and show the, you know, and evidence also of the lack of burdens, which we'll talk about a little later, that is a different story. So, the underlying point is I don't think that it's appropriate to say Crawford means any voter ID law goes.
My own view is voting should, any challenge, any burden on voting should be subject to the strictest scrutiny because it is a fundamental right. And on top of that being obvious to any thoughtful person who's looked through the Constitution and dealt with these issues, there's my Post-it test. So I have all these Post-its here where the Constitution says the right to vote, okay? There's 6 of them. Now, if I were to take these away and put a Post-it where the Second Amendment is, the right to bear arms if you're part of a militia, that's 1 Post-it versus 6. It's a fundamental right.
Oh, it's one of ours, too.
Yeah, I think
Case closed.
Well, I guess we're done. I think that the point is well taken, that if voting is a fundamental right, then, as I teach my constitutional law students, then you would apply strict scrutiny to state laws that infringe that right. And you would try to figure out if the state had a compelling state interest in taking its actions and whether their actions were narrowly tailored to advance their interest. In other words, you are infringing that right to vote as minimally as possible to accomplish legitimate goals. And I think there is, the critics of the Anderson-Burdick test, I think there is a point of view that says what the court's doing with this balancing test is more like rational review than true strict scrutiny. And we're taking a fundamental right, but we're applying a standard of rational review, which is a much more deferential standard to the states. Josh, maybe you can give us an idea of how the Wisconsin voting system and recent legislation in Wisconsin has been affecting the right to vote.
Sure. Let me start by saying this. So Wisconsin, historically, as the mayor pointed out, has had a very robust, accessible voting system. It still, on the whole, has a lot of very positive attributes about it, including same-day registration. We have a long history of successful administration of elections. But over the last 6 years, there has, I think, unquestionably been a concerted effort to restrict access to voting. Our case, One Wisconsin, which I'm as familiar with right now as I ever will be because our Seventh Circuit brief was filed about 12 hours ago. 12 and a half now. We document in that case 8 different acts that have been passed in the last 6 years, and I believe 15 pieces of separate provisions that make voting more difficult. Since then, there have been more restrictions passed. So by my count, we're now up to 9 and 20-some provisions. And what's interesting about the effort is how relentless it is. I mean, there's the things that people know about. There's the voter ID law, and there are reductions to early voting. But then there are a variety of other things that are sort of ticky-tack, frankly, but that make it just a little bit harder for just enough people to vote that it makes it worth the legislature's time. Here's a great example. Until a few years ago, you could send an absentee, clerks could send an absentee ballot to a voter by fax or email, which didn't make a big difference if you were in the same town, but if you were a student studying overseas for the year, could make the difference between whether or not you got your ballot in time and got it back. Well, most people who are overseas for the year as expats are students studying abroad or they're professors, and so you can take a guess about who those people are likely to vote for. So the legislature just made it illegal for clerks to fax or email ballots overseas to voters. They now have to send it by mail. Now that provision was struck down by Judge Peterson. Among other things, he pointed out that clerks had the option of doing it. They were never required to do it. So there wasn't much of an argument that clerks were very burdened by it since they were undertaking it willfully. But there have been a host of changes like that. The sort of crown jewel, I think, of Wisconsin's system remains that it has same-day registration. And as a result of some of the challenges, there's been a sort of re-expansion in some respects. So overall, the state, I think, still has a robust election system and there's good access, but there's certainly been a reduction in that access in the last few years.
Karen, do you want to address the difference between Wisconsin's voter ID provisions and the provisions the court upheld in the Crawford case, the Indiana one?
Well, there are some differences in the provisions, or at least in the record at time, which have to do with what kinds, in the record we made when we went to trial in 2013, what documents you had to provide to get ID. It was much easier in Indiana than it was in Wisconsin. In addition, Indiana had a provision that folks who did not have ID could sign an affidavit of indigency and vote that way, vote a provisional ballot, but it would be counted if they signed this affidavit. We tried, and as some of you may know, Judge Edelman over the summer ordered the state to allow what's called a reasonable impediment affidavit, which exists in a number of states. You had a barrier or burden to getting ID because we wanted a fail-safe at the polls, and that was stayed by the Seventh Circuit, but that is something that they had in Indiana. You could vote absentee by mail in Indiana without ID. Wisconsin has this bizarro provision. So they require you, most people except certain elderly and disabled people, to enclose a copy of your ID with your absentee ballot in order to, even though there's obviously no way to check the ID looking at the voter. And that, again, poses a burden for some voters because those voters still have to get ID, even though no one is going to be able to tell who it is who's sending the ID. And that, again, did not exist in Indiana. And those are, I think, three of the core distinctions. Now we also have, obviously, there are increased number of distinctions between how the law's been interpreted in Wisconsin and other states as well.
The absentee ballot provision has the effect of disenfranchising voters through, I think, what I would call the humor provision, which is the clerk for Madison was,
Yep.
I was talking to her recently, and she said she'll get absentee ballot requests without IDs, and she'll call the people up and say, you got to send in an ID. And the people refuse to believe that that could possibly be the law. They'll be like, but how do you know it's me on the ID? She says, well, I said that I'm not the one who makes the laws. And they're like, that can't be right. But so we actually have people who just refuse to believe that the law could be as ridiculous as it is, and with the impact of making it harder for people to vote.
Obviously, the state has a legitimate interest in preventing voter fraud. Matt, can you outline, what provisions of state law protect against voter fraud already?
Well, the voter fraud issue of in-person voter fraud just doesn't happen. Let's get that out of the way. It's the candle's not worth the game, number one. People don't take the time to go find a name of another voter that might not have voted themselves, pretend they're that person to get one more vote. It doesn't happen. But there are things that do happen, and the most frequent one, and this is back in 2005 when I testified about this, felons voting before they're off paper is the single greatest danger of, I don't want to call it voter fraud, but it's somebody who is not eligible to vote that can cast a ballot in Wisconsin because we have same-day registration, and you show up and they will have proof of residence, and they can register and then vote. And so the state has been trying, and every time that happens, those people get prosecuted. There's just a practice in the district attorney's office. They can't decide on those cases. They lose them all. They lose them all. They end up not being able to prove the intent because it is such a difficult thing for the individual to keep straight that I don't have it now, but as soon as I'm off probation, I do have it. So they lose them, but they prosecute them. But the statewide voter registration database has been updated, and Mark probably knows more about this than I do, but it really now is almost as current as it can be with the DOC records to ensure that at least when it hits that database, somebody who's still on paper will be in the database as they can't vote. What we do now in Milwaukee and other places for same-day registration, since anybody who's still on probation or parole has an address that's registered with the DOC, that address is shared with the local municipalities, and they have a list at every ward that lists every person who is living there who is still on paper that is not eligible to vote. So when people register, assuming they haven't moved and not told their probation parole officer, their name will be cross-checked against that list. So we are trying as best we can to prevent what are really accidental, not fraudulent, but illegal voting. And that's the biggest issue we have.
How many of those cases are there?
It's probably a dozen every year, every presidential year.
If that.
If that.
I want to throw out one other thing, which is there have been incidents of multiple voting, but that's not, I go in and vote as Karen Rotker, and then I go in and vote as Matt O'Neill. That's someone who goes in and votes in a couple of different sites under their own name. So those people have ID. In fact, the most famous case of this was a supporter, I'm trying to think, of the governor, who voted, I think, like 12 or 13 times total in various between the recall and the 2008 presidential elections, including one time where he voted in Wisconsin and then drove to Indiana and used his old Indiana driver's license as ID to vote in Indiana. Okay. The people who multiple vote get caught because people know who they are. Their names show up multiple times. So I think just saying voter, and there are maybe a handful of those too. It's not a huge issue. But I think saying voter fraud collapses everything in to this idea, and then that people are voting as people they're not, and that has not been shown in Wisconsin. There has not been evidence of that. There's been virtually no evidence of it anywhere in the country. And so I think we have to be careful when we talk about voter fraud to be really specific about what it is we're talking about.
Well, Karen, can you now give us some idea of the legal arguments that you made in the Frank case, that challenge?
So the Frank voter ID challenge, which is December 11th, will be 5 years, and I have been on this case since day one. And we're on our third trip to the Seventh Circuit. So anyway, part of the challenge was a constitutional challenge. And while I agree with you about the Anderson burden test being too weak, but that's the test we have. That's the test that Wisconsin's voter ID law as constituted was imposing too many burdens on too many voters, and that the purported benefits to the state, i.e. the supposed fraud suppression or whatever, just didn't, it wasn't going to deter or eliminate fraud. So that was part of it. We also made a challenge under the Federal Voting Rights Act. And while there's been a little bit of mention of Shelby County, Section 2, first of all, Wisconsin was never covered under Section 5, which requires voting changes to be pre-cleared. Whether it should be, I might let Josh respond to that. But Section 2 also prohibits racially discriminatory practices. And so we put in a lot of evidence about African Americans were twice as likely as whites to lack both ID and the documents needed to get ID, and Latinos were 3 times as likely as whites to lack ID and the documents needed to get ID. Even though majorities of all groups had that, we put on evidence of historical discrimination in Wisconsin. We put on evidence of, again, the lack of the state's interest in this particular kind of a voting procedure.
Okay. So the constitutional argument was that the burden on the right to vote outweighed the potential protections under the state law, under the balance.
Correct.
Yeah. Josh, how does the Peterson case, does it make any different legal arguments?
We do. So our challenge is more of an omnibus challenge. I mentioned before the variety of provisions that we've identified. We're challenging them as a group. We have a few additional legal theories, some of which we were able to make because when Frank was brought 5 years ago, first of all, the law hadn't been implemented yet. And secondly, just over time, sort of information has come out about the motives of the legislature. So in addition, we've made the same 2 arguments, that the law unduly burdens the right to vote. That's the Anderson verdict test you've heard mentioned. And that it's a Voting Rights Act violation. And the basic argument there is it imposes a disparate burden on the basis of race, and that disparate burden is linked to a history of discrimination. But then we also brought 3 sort of different variants of intentional discrimination arguments. One is that the law was intended to suppress voting by African Americans and Latinos. Second, that it was intended to suppress voting by young voters. And 3, that it was intended to suppress voting based on partisan affiliation or viewpoint, which is a theory sort of rooted in the First Amendment. And I shouldn't say the law, by the way. Our challenge is that the collective laws were all designed for the purpose of suppressing voting, and that some of the specific laws do it by making it hard to vote if you're young. Some of them do it by making it hard to vote if you're African American or Latino.
So I think there's a perception that the tide is turning in terms of federal judges being more skeptical of state laws restricting access to the ballot. Would you like to comment? Any of you like to comment on the reasons for that increasing skepticism by the courts, and whether that portends a greater likelihood of success in the Wisconsin litigation?
I think some of that comes from the folks that are nominated to the bench by more progressive presidents of the United States. Now, make no mistake, our current senator, who's up for re-election this year, is solely responsible for Wisconsin having voter ID in a rather direct but roundabout way. Because while folks may not remember directly here, Judge Terry Evans passed away 5 or 6 years ago. Professor Victoria Norris from University of Wisconsin Law School was nominated as a replacement, was put forth, and she was all set to go. And our current senator was new into office, said, hey, no one checked with me. I didn't okay this, so he blue slipped her. And she was done. And then he has managed to blue slip everybody else through the process, so we don't have a replacement, which leaves only 10 judges on the Seventh Circuit. So when Karen's case got up to the Seventh Circuit and it lost on a 2-to-1 panel with just a brilliant dissent by Judge Posner. If you haven't read it, it's one of the best pieces of writing you're ever going to read about voting rights. It's a fabulous read. Sad because it's a dissent. But it went up for en banc and lost 5-5. And I can guarantee you that if an Obama-nominated judge would have been sitting on that court, they would have recognized that in Crawford, the Supreme Court said there was no record. In Frank, they made that record in spades. It was an incredible record. Judge Edelman gave a fabulous decision. It was exactly what was missing. But we didn't have that 11th judge on the Seventh Circuit.
So let me just clarify, just for because I've been living and breathing. We actually had a 3-0 horrible panel. We had about the worst panel you could get in 2014 on the Seventh Circuit.
Okay, so his dissent was on the...
Right, and then we went
You're
on.
about to get that panel again, so be careful what you say. No.
We got a very
teasing.
conservative Seventh Circuit panel, and then they split 5-5 on banc. And Posner's dissent was on banc. I just want to note, as a side note, one of those judges who was on our original panel has since retired, not taken senior status, retired. There are now only 9 active judges on the Seventh Circuit. So that's all I'm saying. So we'll see what happens. But I do think, I think the record is important, and I'm sorry, I actually got so entranced by what Matt was saying. I forgot.
Talking about federal
No,
judges. The tide is turning.
I can
The
follow up
tide
because
is
I know where
turning.
you're going on this. The thing I was going to mention is there's Professor Bruce Ackerman at Yale who talks about constitutional moments and how a lot of the way that we have our understanding we do of our Constitution is that enough people get upset with the way things are being done that courts should start doing it differently. My view is that we may be on the verge of one of those moments right now. And I think there are a variety of reasons for that. One is, as you guys were just mentioning, the composition of the courts is changing. And there's just no question that if you want to figure out how somebody's going to vote in a voting rights case, the best predictor is to look at the party of the president who appointed them. But the second thing is, as we've seen more aggressive action by states, both in response to Crawford, but especially in response to Shelby County, we've seen a number of judges who are appointed by Republican presidents who are thought of as conservative judges say, you know what, this is a bit much for me. So in the Fifth Circuit, for example, which is universally regarded as the most conservative court in the country, the voter ID law was struck down with a lot of Republican judges in the majority. And so I think there is some recognition by judges that there's something going on that's a problem. And then the third thing is the evidence has just accumulated nationwide, both that there is just no in-person voter impersonation fraud. At the time Crawford was decided, there was not a lot of research on that. Now there have been lengthy, intensive court trials in states across the country, and universally we haven't had any cases of in-person fraud in 15 years. We had one case, it was a guy who was testing the system. It's that sort of evidence. And at the same time, there's much more recognition that the laws do impose burdens on voters and are often intended to make it hard to vote.
And let me throw out one other reason that I think this year in particular, it's what happened, it's the status of the Supreme Court right now. So the judges who are on the trial and appellate bench have a little more freedom because they know that what they decide is likely to stand. And I mean, I think it's why the result of the election and who ends up on the Supreme Court is of enormous constitutional moment, for many issues, but voting rights is one of them. Mm-hmm. Because I hold no illusions that if Justice Scalia was still alive, I am far less convinced that a lot of the appellate decisions that have been issued in the past few months would have survived.
Yeah, I agree with that. I think that appellate judges don't stick out their neck if they think they're going to get reversed. And the absence of Justice Scalia on the Supreme Court is creating more confidence with some appellate judges.
I think the Ninth Circuit doesn't know what to do with itself. It's used to having its cases play ping pong with the Supreme Court, but all of a sudden their decisions keep actually being enforced.
We just have time for a couple quick questions, and then I want to open it to the audience. From a practical standpoint, do any of you foresee any issues in the coming election, some practical difficulties or potential surprises? I'll start with you, Matt.
I just got done with a meeting at District Attorney's Office where they bring both sides in for a meeting, and one thing I asked of my Republican counterparts is, hey, I've seen your candidate out there saying it's rigged, it's fraud, 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 and I see on his website he's got a, hey, sign up and help us be a poll observer. Are those your people? Are you training them? And the people from the Republican Party of Wisconsin said, no, that's Team Trump, and they haven't talked to us. So the one outlier here is, what does that mean? Who is going to sign up to look out for this non-existent fraud? What are they going to be trained? What do they think is going to be going on? Will they understand the rules for observers in Wisconsin? And what is that going to mean? And will it create any commotion on Election Day? And I'll say this, I don't think so. I think they know Wisconsin's a lost cause. They may all be angry about something, but I don't think there's going to be a big push here. And luckily, we're in a state where our chief election inspectors that run our polling places have, for the most part, been doing it for a long time, and they know what the hell they're doing. So I don't foresee that being a problem, but it's the one bogey out there that I can't predict what will happen.
So let me throw a couple of things. One other thing that's important about observers in Wisconsin that I just want to make sure people know, they can't challenge unless they have personal knowledge of the reason for ineligibility. So, they can't just walk into a polling place and say, let me see your ID, or I don't believe you're this person. They have to have actual personal knowledge of something, and that's really critical. And the chiefs can enforce it. We are somewhat concerned about the confusion. That I did a telephone town hall with several hundred people last night, and there is so much confusion about this law. So, for example, we got, I think, a dozen questions. People think there's a special voter ID, and they don't understand what the voter ID is. There's confusion about registration versus voting. So we're just really concerned about confusion. Is the mayor still? No, he left, but I'm going to throw it out anyway. We're also concerned, the city of Milwaukee has been short on poll workers. So for those of you who live anywhere in Milwaukee County, you could actually sign up for a half day or a full day to be a City of Milwaukee poll worker. We'll also say that, I assume, Madam, we for Wisconsin Election Protection are also recruiting attorneys and law students as observers. But we are also telling people if you're willing to work the polls, because having good, smart, competent people who can explain things and treat voters respectfully and fairly is actually a huge issue in making this election run smoothly.
Yeah, I would agree, I think. Somebody asked me about a month ago, she said, I'm debating what to do on Election Day. Should I do election observing at the polls, or should I drive people to the polls? And I said, drive them to the polls. The odds you're going to have an issue at the polls are unlikely. And then I started looking at the newspaper. And so I'm actually going to send her an email today and say, change of plans, go to the polls. One of the laws we're challenging is in the 2012 recall, as you may recall, it seems like a different lifetime now, but politics were fairly heated in Wisconsin, and there were all sorts of problems with election observers, particularly in Milwaukee and Racine. And Racine has issues for a variety of reasons, one of which is it often has very closely contested state senate elections. And so one of the things the GAB, which was then in charge of elections, did was said, we have this informal policy, you can force observers to stand 6 to 12 feet from where voters check in. So there's a buffer. And in the 2012 presidential, poll workers were trained up and they did a really good job with that, and there were fewer problems. They weren't non-existent, but there were fewer. And so the next year, the legislature passed a law overruling the GAB rule, saying that the observer area had to be 3 to 8 feet from voters. And just to give you a sense, Matt is certainly within, that's about 3 feet.
That's right.
So there's the potential for a problem because you have poll workers, you have observers who can overwhelm poll workers. Most poll workers are very good, but as anybody who's been to a polling place knows, you're not going to necessarily get somebody who's on top of things. They do have the ability to kick somebody out on the spot. So if you are doing election observing, feel free to pass that information along. The second issue is with respect to voter ID. There are some problems with people who actually don't have IDs. That's a real issue. The bigger issue in terms of number of voters impacted is a lot of voters think they don't have an ID even though they do. Like you said, some people think there's a special voter ID they don't have. Other people may have a passport or something like that and they don't realize. And then there's the reverse issue, which is people think they have an ID but they don't, so they'll have an out-of-state ID. The messaging you always hear is you have to have an ID to do everything, so why don't you need an ID to vote? And people say, I use my Minnesota driver's license for everything. I use it to get on a plane. I use it to prove my identity. I just can't use it at the polls in Wisconsin. So confusion relating to that issue is going to be something to watch out for. My advice to everybody is to encourage people to vote early, because if you have an issue early voting, you can resolve it. If you have an issue on election day, you might not be able to.
Actually, none of this matters because I have it on good authority, the election is rigged. We have a few minutes for any questions from the audience, and I'll repeat your question for the microphone. Yeah.
Well, I guess it's just more of a comment to add that the other thing that I think is the problem is, in addition to thinking that you need a special ID or whatever it is, a lot of people think that if the address on their ID
Yep.
is not their current address, and there's so much confusion between proof of residence and proof of ID. And I was at a training to work with the polls, and there was confusion amongst the people who are going to be working at the polls about that. So that was kind of scary, and I think chilling.
So let me just say clearly and succinctly, so everyone here knows and can share it with your friends. Your ID, your driver's license, does not have to have your correct address, period. No discussion, no debate.
To vote.
To vote,
Suspended or revoked.
yes,
A lot of people think, well, my license is suspended.
right.
Right, so you can vote with a suspended license as well. Other questions? Yes?
Can you just tell us where things stand with people being able to get a receipt for voting at the DMV?
I have a joint status report due to Judge Peterson tomorrow. The latest, and we have one of our election commissioners here who probably can talk to you about it, is the DMV has said that anybody who shows up at a DMV with whatever documents they have that fall into certain categories, basically to prove your identity, residence, citizenship, will be given an ID, a temporary receipt they can use for voting. It'll come in the mail within 6 days, as long as you bring whatever you have. So if you don't have a birth certificate and you don't have a way to prove your citizenship, grab what you have and bring it in, and they'll get you something. In practice, so far, it has not worked out that well for a variety of reasons. One reason is DMV employees are not familiar with the rules. So people will show up and they'll say, nope, I can't help you unless you have a birth certificate. Somebody working for a group called the Vote Riders, which helps people get IDs, started recording her interactions at DMV because she couldn't believe what was happening. As a result of that, Judge Peterson in our case has ordered a variety of patches, as he called them, to try to get us through this election. But one of which is the DMV has done much more aggressive training. So the hope is that now when people go to DMVs, they will have the ID offered to them and get it in the mail. That's not to suggest that I think this is a good solution, but it's the one we have for now.
And I just want to say, if anyone here finds out or hears about anyone who has tried to go to DMV and can't get ID, we want to know. You want to know, or I want to know. One of us needs to know that. Or you can, Wisconsin Election Protection on Facebook, you can also use that as a messaging vehicle, because that's really important. Although I did hear yesterday, someone I knew took someone to DMV and they said all the workers were terrified. Which is great, which is about time.
Yeah, everybody at DMV now thinks you're recording them, which is actually even makes the service better.
Okay, we have time for one more question. Yes?
While we're on the topic of attempting to get an ID, Josh probably knows my current obsession here. I'm not a lawyer or a law student. I was brave enough to show up here anyway, so I'm giving some credit.
She has testified in a voting rights case. I can attest to that.
So I'm just on the streets working with voters every day. And the big problem that has yet to be addressed in any of these cases, as near as I know, is the out-of-state driver's license. You cannot get an ID unless you surrender your out-of-state driver's license. Now, you may say, what's the big deal? Well, it's a big deal if you're homeless, penniless, and living in your car. You're not going to give up your driver's license so that you can vote. It's a big deal if your grandma moved in with you. She's not really thriving anymore, but she just wants to hold on to that Minnesota driver's license in case of an emergency or something. There's quite a big category of people who really cannot get an ID so that they can vote here. The Wisconsin law only requires you to get the ID, the driver's license, within 60 days of moving to Wisconsin. You only have to be here 10 days to vote. So there's some big discrepancies here, and I kind of feel like nobody wants to grapple with with it, but I hope Josh is going to tell me he's grappling.
I have, well, what I think I might have is bad news. We actually mentioned this issue at the last hearing we had with Judge Peterson. He said, I'm aware of that issue. I was aware of it when I ruled. But, you know, I haven't seen enough of a, you know, specific issue with people coming in. Again, I'm not disagreeing with you that it's an issue, but that's sort of the latest that we've heard.
And Judge Edelman did rule on it too, and he ruled negatively as well. And we know it's a problem. Again, if there are specific people, we would at least like to talk to them and, you know, for the future, see what could be done to show that it in fact is a problem, because they don't seem to believe it right now.
You're only at the Frank case is only at the preliminary injunction stage, so that there may be another Frank trial.
Frank 3?
So, you know, you guys could be going to the Fourth Circuit, Seventh Circuit a
This
few
is
times.
maybe four times. No, there's going to be subsequent proceedings, which is why we continue to want to find people who are affected. I can't promise we'll get them all ID to vote in November, but we want to be in communication with people to try and protect them for the future.
I wish we had more time to learn from our distinguished panel, but I'd ask that you please give them a round of applause. Thank them very much. I want to thank Mayor Barrett, who's no longer with us, Attorney Craig Mastantuono.
That sounded
He's left the building. Like Elvis, he has left the building. Attorney Craig Mastantuono, who's still here but has to leave quickly for court. I'd like to thank all of you for attending, and in particular, I'd like to thank the Milwaukee chapter of the American Constitution Society and the Marquette Law School student chapter as well. So thank you and have a great day.
Thank you all.